Hey everybody, good morning and welcome to the adibiip group Innovators Live Q&A, your daily live cast, bringing you guys awesome intellectual property content every single day of the week, trying to provide as much invaluable information as we possibly can to help you guys navigate the business world from an intellectual property context. I'm trying to bring you guys awesome content around patents, trademarks, copyrights, trade secrets, anything involving intellectual property. We want to provide clarity and answers for all of you. If you guys have specific topics or questions that you want us to cover on the show, please send them our way. You can email Victoria at adibiip.com. Shoot her an email. We love to get your guys' feedback. We're trying to create relevant content that you guys actually want to see. This can be whether from deep dives on specific companies to specific in the weeds questions about patents, trademarks, or copyrights. Now, we also have a community number. Feel free to text 415-943-5193, 415-943-5193. Would love to get you on our text community. If you text that number, we'll actually be able to communicate with each other, and I'll be able to answer your questions directly. And then I'll also, you guys send me ideas, I'll try to get them on the show. So please join our text community. This is episode number 132. We're going to do some awesome, more awesome content as you're going to discover. Before we do that, though, let's do a quick recap of what we did yesterday on episode number 131.
So on episode 131, we looked at Off-White's brand and their marks and all their zip ties and stuff.
So we checked out the zip tie logo. We checked out their shoe logo. Thanks a lot, Victoria. Thanks for guiding us through that. And then it was interesting because we were chopping about it afterwards, and that's actually the inspiration for this particular episode. And I'll let Victoria introduce that.
Today's episode is what challenges did Off-White face when trying to trademark their zip tie mark?
So it's interesting because it wasn't so matter of fact. There were actually quite a few office actions that were involved that the applicants actually had to respond to in order to get the zip tie trademark. So I want to go over that with you guys. I want to show you guys what were some of the objections that were raised by the examining attorney. It was actually kind of interesting. It was kind of rocky in that there were actually multiple examiners that were involved in it. So we're going to look at it today, and I want to show you guys just how to navigate from starting from tsdr.uspto.gov, how to find the mark, and then how to look at the prosecution history to gather information and get a sense for what was involved in protecting this particular mark. So let's start from the top. I'm going to share my screen with you guys. The first thing you're going to want to do is you're going to want to go to tsdr.uspto.gov. That's the place to start. So once you're here, what you're going to want to do is you're going to want to search for trademarks, and we're going to search by company name. So all you do is click search trademarks. We're going to do a basic word mark search. I'm going to zoom in so you guys can see nice and clearly. And then I'm going to type in Off-White and owner. Okay. First things first, what I'm trying to do here is I'm trying to get to the zip tie mark just so that I can actually review those records. Now, once we're here, I'm going to click on image list so that I can quickly identify the mark that I'm looking for. So here's the mark right here. So this is the mark ending in 456. So this is the actual mark. Now, as you can see, it's still technically it's still pending. But let's take a look at it, and let's look at what they're facing and trying to get this protected. So I'm going to go ahead and click. So I'll just go back to what I just did real quick. So when you're here, if you want to look at status, all you do is click on this TSDR button right here. So we click on the TSDR status. As we can see, it's still pending. A non-final office action was issued, sent to the examining, sent to the applicant. So let's take a look at it. Let's see like what sorts of things that they're up against. Now remember they're trying to cover footwear here, and of course Off-White LLC is the company that owns it. It's a limited liability company based in Illinois, and again, the prosecution history has been very interesting because it's been going on since 2018. So let's take a look. Now, this episode I think is going to be really, really helpful because a lot of you do put out unique designs out there, but you also possibly might want to consider protecting actual designs and shapes of goods or things that go on shapes and goods that are unique. Excuse me. Excuse me. So let's get into it. So first things first, we're going to click on documents. Now, what I want to do is I want to actually show you guys. So this is the original specimen that was submitted. Excuse me. As you can see here, it's attached various goods. excuse me, here it's attached to a shoe. So let's actually see what was some of the early rejections that were raised. So this is initially examined. So this is the first office action that was entered by the examiner. Now I'm going to go ahead and zoom in here so you guys can see. But basically what we're looking at is they basically raised several issues. So one was that the goods, there was a likelihood of confusion, for example, that was raised, and it was over 2 prior marks. Now these were eventually overcome. I'm going to open them up real quick just so that you guys can see what I'm talking about. So this was one of I'm having internet's a little slow here. My apologies, viewers. So this was one of the marks. It's now actually been abandoned, interestingly. One of the two was. This was not, but just red. And again, this mark was covering protective gear helmets under Class 9. But the examiner entered this rejection for some reason. Now, if we go back, though, we can see there's also another mark. This one here, that was also the basis for the rejection. And I'm going to pull it up for you guys here. And now this one was canceled. This is also red. And this is also covering Class 25 goods, which is clothing and athletic use. So now what's interesting is that the examiner entered a likelihood of confusion, but not just that. The examiner also entered other rejections as well, in particular that there was functionality involved. So basically, the examiner was saying that there was functional matter that was trying to be protected with trademark, and that's not allowed. So those are the two sort of the initial primary hurdles that were involved. Now, I'm going to click back, and I'm going to show you guys some of these other so basically, a response was submitted. In the response, if you look at it, we can take a quick look here. But basically, arguments were presented as to why it was not, there was no likelihood of confusion. And basically, what the examining attorney, what the applicant's attorney did was they provide a bunch of evidence just showing the notoriety of the mark, the uniqueness of it, how it really served as a status identifier, solely used as an indicator of source. You guys should definitely read things like this. I mean, especially if you want to learn and really get into the weeds of it, you can learn a whole lot. Basically, what you're going to discover is that there's this case in Ray Morton, Norwich, and products, and this sort of sets the multi-factor, the 4-part test as to determining whether or not something is in fact functional or can actually be registerable as a trademark. So they went through it, and basically what happened was, and they also argued the refusal, right? So they also argued that there was no likelihood of confusion, and that they operated in different channels of goods. Now, what's interesting is that in this particular case, let's see what happened next. So basically what happened was after this response was filed, the office action, the rejections actually changed. And interesting because it was actually reassigned. So it got reassigned to a different examiner. But the functionality refusal actually remained. And also a non-distinctive configuration refusal was entered. Now, what's interesting also is that the likelihood of confusion was withdrawn. So that was actually successful. So remember, likelihood of confusion also referred to as 2D. So this was actually withdrawn. But again, we're dealing with functional refusals now. And effectively what the examiner is saying is that it has a functional purpose. So let's see how the applicant responded. Remember, this is an interesting case because it's still pending. It hasn't yet been resolved. So this is the mark. This is the mark that's shown. This is what was applied for. And again, handbags, wallets, backpacks. Now, in this argument, basically what they say is that the actual mark itself doesn't have any functional purpose, essentially. It's largely just a source identifier for status, right? So it shows off, this is what's emphasized here, it has no performance value. It's just a glorified status symbol. And also it's interesting because they provide evidence that it's an inherently distinctive mark. So they go over the Seabrook factors. Let's see how the office responded to that. So in response to that, again, this is just a lengthy back and forth, but it's really interesting because it's such an iconic mark. And so it just goes to show that even if you do have significant success, commercial success, you might still be in the situation where you have this mark here that's still pending. So basically the office responds by saying, hey, we need more information about how the mark is actually being used. So they want to know, is it attached directly to every listed item? Is it permanently attached? How is it actually attached? And then they also want to know how, where, what's printed or imprinted on the tag, how does it differ in shape and size? So, and they also maintain the functional refusal. So now the office is basically saying, hey, give us more information. Oh, and by the way, we're also going to maintain our non-distinctive configuration refusals and functional use refusals. And so then what happens is the applicant then responds by basically arguing that. So they basically focus just all on footwear. So even though they initially filed under handbags, wallets, and backpacks under 18, they narrow it to just clothing under 25. And then what the applicant's done here is essentially answered the examiner's questions. Right, so it's a zip tie. It's worn on and it's used on footwear products, closed and looped around a shoelace on the actual footwear. And then in turn, the applicant's attorney actually answers every single question very clearly. Yes, red tag's attached to every item listed. It can be permanent if the consumer so chooses. In other words, obviously the consumer can take it off if they want to, and loop around the shoelace, and the zip tie can be removed, but consumers tend to not remove it, interestingly, because it serves as a unique and distinct indicator of source, right? So this is, in a sense, this is answering the question, but in a way that's trying to promote this applicant's argument in that this zip tie actually serves as a unique source identifier. So all the questions are answered, and then additional arguments are presented as to why it does not function, why it doesn't serve any function, any function other than identifying the source of the goods. So pretty interesting. And then there's additional arguments made as to why it's distinctive, and based on the fact that it's achieved high level of notoriety and fame. And there's a bunch of multimedia mentions, and then these are actually attached as exhibits. Now, what you're going to notice, there's 282 pages in this response, right? So while this response is seemingly short, it's only a few pages, they present hundreds of pages of proof showing notoriety and success and citations in media. So I'll show you guys what I'm talking about. So let me see if I can zoom out here so you guys can see. So this looks like, okay, so this is an article in Vanity Fair covering Virgil Abloh. I'm going to keep going forward. This is the Vanity Fair article. So they're basically presenting proof that it's been widely accepted as a source identifier by citing these huge publications. So here's a Vox article on Virgil Abloh. And again, we don't need to go through all of these, but I just want to give you guys a sense of the kind of proof that has been submitted. For example, here, okay, here's a New Yorker piece. Now let's see what the office does with this. So there's all this evidence that's presented, and we don't need to go through all of it, but this is another exhibit. This is a Vogue article. So let's see what the office does. So this is what was submitted in response. And then what ends up happening is, so I can pull it up for you. Basically, now there's a different type of refusal. So the examiner is basically saying, okay, this is now merely ornamental. And this is a relatively recent office action. So I think we should come back to this, do another episode in the future, see how the applicant actually responds to it, actually deals with it. But it's really interesting because, as you'll see, there's actually a different examiner altogether. And so it's actually successful in that the functional and configuration refusals have actually been withdrawn. So all that evidence that we saw that was submitted before, in a sense, was effectively persuasive. And so pretty neat to see. Need to see the flow, how this application has actually been progressing through the trademark office, the obstacles that have been in the way of Off-White, but how they are working towards trying to actually get it through. Now, what's interesting is that this is a whole new refusal, and they're basically saying that it's purely ornamental. So they're basically, what the office is basically saying is that the red zip tie only serves an ornamental function. So it's basically additive. So it adds to the decorative value of the good, does not serve as a source identifier. So that's the argument that the office is now making. So it's really interesting. Now, what's interesting is that with these rejections, one option is to actually amend the application to the supplemental register. And we should actually do some more content around the supplemental register, because often for merely descriptive rejections, for example, you might actually end up better off just going into the supplemental register. So I think what will probably happen, now if I had to guess, what might be possible is they might be able to show acquired distinctiveness. It's just based on the length of time that they've been selling the goods. So that's probably if I had to guess, that's probably how they're going to respond. And hopefully that will actually get this registered. So pretty interesting to see. Again, this is episode number 132. I wanted to show you guys what the challenges even a large entity, a large famous brand can go through in trying to get their mark actually approved. So I hope you guys found this content helpful. If you guys have specific questions that you guys want covered on these shows, please email them to Victoria at adibiip.com. Shoot her an email, send her your suggestions, send her your ideas. Anything that you guys want, we'll do our best to cover them on the show. And then as far as our community number, we'd love to have you join 415-943-5193, 415-943-5193. Text that number. You'll get direct access to me. You can send me your questions, show ideas, suggestions, anything that you guys want covered on the show. Send them to that number and we will get your questions answered. Hope you guys enjoyed watching. This was episode number 132. Again, go back and watch episode 131. We'll do a deep dive of Off-White's trademarks. But rewatch this episode. I think there's a lot of gems in here, a lot of useful stuff. See how you can actually, if you go back and study this, you can actually see really good examples for how you can overcome those functional refusals based on function, and really good example. So thanks so much for watching. Hope you guys enjoyed this, and looking forward to seeing you guys tomorrow for episode number 130.